of AQUINO versus the Municipality of Malay, having the General Register Number of 211356. The date it was decided on, September 29, 2014. The petitioner was Crisostomo B. Aquino. The respondent, Municipality of Malay, The ponente at that time was Justice Velasco Jr. In the exercise of police power and the General Welfare Clause, property rights of individuals may be subjected to restraints and burdens in order to fulfill the objectives of the government. Facts. The petitioner, Crisostomo Aquino, was the President and Chief Executive Officer of Boracay Island West Cove. He filed a petition for review on certiorari under Rule 45. Impugned the decisions of Municipality of Malay for dismissing his applications for zoning compliance, further issuing demolition closure and demolition order, and the Court of Appeals for denying his petition for certiorari for being the improper remedy. On January 7, 2010, the company applied for a zoning compliance application and building permit, covering the construction of an additional 3-story hotel over a parcel of land covered by a forest land use agreement for tourism purposes, but were denied by the municipal zoning administrator on the ground that the proposed construction site was within the no-build zone under Municipal Ordinance 2000-131. Thereafter, the respondent issued a cease and desist order enjoining the expansion of the resort, and Executive Number 10 ordering the closure and demolition of Boracay West Cove. The petitioner asserted that the issue was alleged and executed with grave abuse of discretion, arguing that the judicial proceedings should initially be first conducted before the respondent mayor could order demolition of the company's establishment. While on the other hand, the respondents argued that because the municipal mayor had expressed power under the LGC or Local Government Code, the demolition needed no court order to remove illegally constructed buildings. The issues was whether or not the procedural due process of due notice and hearing was complied with, and whether or not judicial proceedings should be first conducted before the respondent mayor's executive order demolition of the company's establishments. Rulings. Yes, the procedural due process of due notice and hearing was complied with. First, the basic rule that the public officer enjoys the presumption and regularities in the performance of their duties. The burden was in the petitioner to prove that Boracay West Cove was deprived of the opportunity to be heard before Executive Number 10 was issued. Regrettably, the cease and desist order issued by the LGU and the assailed Executive Number 10 itself was never attached to the petition before this court, which documents could have readily shed light on or not petitioner has been accorded to the 10th day grace period provided in Section 10 of the ordinance. In view of this fact, the presumption of regularity must be sustained. Second, as quoted by the petitioner in the petition before the Court of Appeals, the assailed Executive Number 10 states that the petitioner received notices from the municipality government of Malay on March 7 and 28 of 2011 prior to demolition of the establishment, requiring Boracay West Cove to comply with the zoning ordinances and yet failed to do so. If such was the case, the deemed grace period can be observed and establishment was already ripe for closure and demolition by the time Executive Number 10 was issued in June. No, the petitioner's right to due process was not violated for lack of judicial proceedings prior to the issuance of demolition order. The government may enact legislation that may interfere with personal liberty, property, lawful businesses, and occupations to promote the general welfare. One of such pieces of legislation in the Local Government Code, which authorized cities and municipal government acting through their local chief executive to issue demolition orders and to hear issues involving the property rights of individuals and to come out with effective order and resolution thereon. Pertinent herein, Executive Section 444 of the LGC of the empowered of the mayor due to the closure and the removal of illegally constructed establishment for failing to secure necessary permits. Though the court does agree on the petitioner's content that under the LGC, the Sangguniang does not have the power to authorize the extrajudicial condemnation and destruction of a nuisance of per accidents, still, the Supreme Court ruled that the LGC or LGU may nevertheless properly order the hotel's demolition without due hearing thereon in the tribunal court, because the exercise of police power and the general welfare clause provided in the Constitution, property rights of the individuals may be subjected to restraints and burdens in order to fulfill the objectives of the government. Hence, the right to due process was satisfied and case at bar.